All right, we'll give people a couple of minutes to finish logging on here. While we wait, we have a disclaimer here on the screen. It basically says, anything we talk about today is not considered legal advice and nothing is protected by attorney-client privilege. So if you do have specific questions that contain confidential information or just questions in general, feel free to direct them to the firm. We have our phone number there, and our email is info@therodmanlawgroup.com. So we'll just check in on the attendees, then get started. Okay, looks like we have a pretty good amount. So yeah, we'll get started here. My name is Rebecca Spence, and I'm an associate attorney at the Rodman Law Group. If you didn't know already, this webinar is put on by the Rodman Law Group, and we're a firm that provides business counsel to the cannabis and hemp industries, including growers, retail outlets, transporters, and ancillary businesses. With expertise in practice areas that affect cannabis and hemp businesses, the Rodman Law Group assists clients on a range of issues, from corporate startup to corporate structure, licensing matters, regulatory compliance, complex business transactions, and of course, intellectual property. So we're hosting this webinar today to discuss the relationship between cannabis and intellectual property. And because of our panelists' vast experience in the space, we hope to provide a unique point of view for our attendees. So speaking of our panelists, I'll just give a brief introduction and then let them take it away. First, we have Nadal Ashmore. He's a partner at the Rodman Law Group. He's been working in the space for over 6 years, which I believe is his entire professional career. He'll be able to expand on that a little bit more, but he's spoken on multiple panels pertaining to this issue, these very same issues, and yeah, excited to have him here. Next, we have Dave Rodman. He's the founder and managing partner of the Rodman Law Group, and he has also represented clients in the cannabis and hemp industries for his entire professional career. And having worked with both of these guys very extensively, I feel as if they complement each other in ways that will be very beneficial for this webinar that we're hosting here. So I'm excited to hear how they bounce ideas off of each other, and yeah. Nadal, anything to add?
No, thank you for the glowing introduction, Rebecca. We're happy to be here, and thank you all for joining us. Cannabis and IP is a, for many, for nerds, for Dave and I, a very interesting topic, and one that's really had some substantial developments over the last, just couple of years. So when we were thinking of ideas for a webinar, this was foremost on our mind, so that we can, help share some of the information we've learned over the last few years and help businesses protect themselves and protect their valuable intellectual property.
Awesome. Dave, anything to add? Introduce yourself. Awesome. Well, thank you guys again so much for being here today. We'll jump right in by just asking you guys to give us a brief summary about the different types of intellectual property protections available out there.
Sure. So there are roughly 4 main types of intellectual property protection. There's patents, trademarks, trade secrets, and copyrights. Trademarks are the oldest, well, actually, trade secrets are the oldest form of intellectual property. It's pretty self-explanatory. You keep something secret, you can use it and benefit in economic sense. This is how Coca-Cola protects their secrecy, their secret formula. They just don't tell anybody it, and it exists for as long as that secret stays secret. Then trademarks are the second oldest form of intellectual property. There is a form of trademarks that have existed in some shape since 1300s. They've been codified in this country since 1947 under the Lanham Act, and they protect an image or a reputation associated with these services, provision of services or the manufacturing of goods. Then you have patents. This is actually something that is protected by the U.S. Constitution in America. It's also a very ancient form of intellectual property. And patents are basically a protection for an item or an invention. It's a tangible protection. Lastly, but not least, but probably least as far as this conversation goes, is copyright. And copyright protects an idea once it's been fixed in a tangible medium of expression. So a song written down as musical notes or played on an instrument, an artist's rendering of an object, a written speech, a book. These are all things that you can copyright, but it has to be fixed. It has to be written down. It has to be a sculpture. It can't be ethereal. I think that this conversation will focus mostly on trademark, potentially trade secrets. We'll probably touch on patents, but copyright we'll probably skip over.
Yeah, and we'll dig a little bit deeper into that in just a few minutes. But first, I just want to clarify for those who don't know what the difference is between the legal definitions of marijuana and hemp.
I'll take that, Dave. That's a good question, Rebecca, and the importance of that is that we'll talk about it later, but certain intellectual property protections can only apply to lawful goods or goods that are lawfully in the stream of commerce. So when we think about marijuana or hemp, it's really the same plant, same genus and species of plant, cannabis, that creates these different classifications. But hemp is the plant that produces up to 0.3% THC on a dry weight basis. If it's got less than that threshold, then that product is not considered marijuana. It's actually carved out explicitly in the Farm Bill from 2018. And so what that has created now is these two classifications where the federal government might look at a marijuana product, something at or above 0.3% THC, and say, this product is not lawful. They might look at an identical appearing product, but that product has a THC content of, below that 0.3% threshold, and is considered hemp. Any CBD product derived from lawfully produced hemp, we'll talk about that in a few minutes, but you may have the option to apply for federal intellectual property protections if your product is derived from lawful hemp. Whereas it's just a big no-no if you've got a marijuana product, for example, you're not going to get a trademark on it. Dave, if you want to add anything, please feel free.
I would just add that, as Nadal said, you can't get a trademark on it, and that's because there's a morality clause in the Lanham Act, which is the enabling statute for the U.S. Patent and Trademark Office, specifically trademarks. You can, however, get a patent on something that is not federally legal. You cannot enforce that patent because patent infringement cases are by nature heard in federal court. So if you were to if you go to the USPTO's website and you look up marijuana patents, there's something like 3,000 issued patents that involve cannabis sativa L, and specifically marijuana. That's well and good, but as part of getting a patent, you have to describe the secret sauce. You have to explain how you did what you did in order to get that patent. So you have something that's novel and unique. You think, okay, I'm going to go the normal business route of getting patent protection for it. And that makes sense if you're making widgets, if you're making cell phones. But if you're making a product that's illegal, you're disclosing to people how to do it, and then you're getting a patent and you are not able to enforce that patent. So until the laws change, it is generally ill-advised to apply for a cannabis patent. Now, that does not apply to cannabis equipment patents, and there are a ton of those. You know, things related to extraction, things related to consumption, like specifically smoking devices. Those are patentable and have been patentable and are enforceable for the most part. I'm kind of smoothing out the edges a little bit, but in general, when we advise our clients, there is hardly ever a time when we suggest that they pursue patents, because there's really a whole lot of work for nothing.
Right. So what kinds of IP protections do you recommend to clients? You know, what's available out there for cannabis companies themselves?
So I'll take first crack, Dave. Like Dave mentioned a minute ago, trade secrets is probably the oldest and also the most common form of intellectual property protection. Certainly that's available to a cannabis company, be it a hemp or a marijuana company. And the idea, as Dave said, is this is information that you've got, how you grow your product, how you manufacture a certain recipe that only you know, and that's not generally out there in the ether for the public to utilize. So as Dave mentioned, first and foremost, keep what you know secret to the extent possible. But beyond that, we recommend trademarks as often a very solid mechanism to protect IP. And there are trademarks at both the federal level and the state level. Like Dave said, the Lanham Act passed in the 40s is really, it's our federal enabling statute to protect intellectual property, to protect goods that are goods and products that are in the stream of commerce. Before that, there was a disjointed effort by federal government to pass legislation that either was way too restrictive or not restrictive enough. Eventually, in the 40s, we settled on the Lanham Act. And the idea is that now you've got a codified rule, a codified set of rules that if you put something out there in the world and you are the first to use it, or you are the first to obtain federal approval for that good, for that product, for that class of good or product, you can have federal protections and you can enforce using federal statute against somebody who infringes on your trademark right. Again, there are also state trademarks, which I think we'll talk about in a bit, but I would say primarily trade secrets and trademarks are your go-to mechanisms for protecting IP if you are a cannabis company. There are patents. Dave talked about patents a bit, but for now, until you can fully enforce your patents, you might spend a lot of time, effort, and resources obtaining something that you just don't have the right to enforce yet.
Dave, anything to add?
I think the important thing to keep in mind when it comes to trade secrets is, we've just hammered it into the ground, keeping it secret. But what that means is kind of, we need to unpack it a little bit. Even just to go back to patents, actually, to explain this, the idea of all these things are so that you can benefit economically from what you've created. So if your business model is volume and you want other people to be able to make your thing, you patent it, and so you license it out. Maybe you make it yourself and you license it out, but you have a set period of time that you have exclusive right to do that. It's between 20 and 30 years with a couple of exceptions. And that's the trade-off. You have a limited amount of time, but you kind of enforce your right around everybody, and you can benefit from other people working off of what you have. Trade secrets, you have to keep it secret. It's the reverse trade-off. As long as you keep it secret, it is always your IP. You always can have the exclusive rights to it. So there's a line that you need to kind of walk there. So obviously, Coca-Cola is a gigantic company with hundreds, if not thousands, of employees, all involved in the manufacturing of Coca-Cola, and they protect their trade secrets through contract. And their documents with their employees would have injunctions in them. They would have damages provisions, massive damages provisions, in an effort to kind of coerce them to keep from disclosing anything to the outside world. Because while the individuals may know certain things. It's really the outside of the company that we're talking about. We're saying keep it secret. Now, if we're really talking about Coca-Cola, it's kind of an interesting analysis because they apparently do only allow the recipe to be known by 2 people at one time. But, you know, at the end of the day, a bunch of people are adding corn syrup to a mix. A bunch of people are adding, you know, other flavorings and coloring. So in order to really be effective on trade secrets, you have to police how the people who, I mean, if you're going to be effective in having a trade secret and also make money with it, you're going to have to let some people know what's going on. So to protect that, you have to really lock them down through contract.
I'm sorry, Rebecca, didn't mean to interrupt, but I think when we're talking about protections available for intellectual property known to or owned by cannabis companies, I think we really need to talk about, come back to this idea that there are certain protections you know, that most businesses might be afforded that a cannabis company is not afforded. So when we're talking about trademarks, for example, let's say you have a topical cream, doesn't contain any derivative or compound of the cannabis plant in it. It is just an ointment. You know, there are tons of products out there that have federal trademark protections for their cream or their ointment. Once you start adding compounds from the cannabis plant, you run into potential issues with both the Controlled Substance Act and with the FDA regulations, specifically the Food, Drug, and Cosmetics Act. So I think it's very important to note, probably now, before we get too much further in this conversation, that there are classes of goods, even though hemp is carved out from the Controlled Substance Act, it's no longer a part of the definition of marijuana. Hemp can be lawfully cultivated pursuant to the 2018 Farm Bill, and derivatives, compounds derived from hemp, including CBD, are lawful to possess. Once you start putting that CBD into a product designed for human or animal consumption, including some creams, including food, beverages, you know, dietary supplements and things of that nature, the U.S. Patent and Trademark Office will actually reject trademark applications if you are seeking a trademark for a good that is not lawfully in the stream of commerce. So again, food, beverages, dietary supplements, things like that are going to be non-starters. But Dave, you could talk a little bit about the types of products that that can involve cannabis or cannabis-derived compounds that you might be able to get federal protection for via trademark.
Sure. I actually want to rewind a little bit and be very clear that when we say, Nadal was saying protection for the goods, we're not talking about protection for the goods. We're talking about the identification of the goods. And so, yes, he's correct when saying that there are certain types of goods for which you cannot have protection for your brand on that good. It's not, trademark doesn't protect the actual thing. That, I want to be very clear about that. But back to your point, Nadav, no class of good, 1 through 47, whatever it is, will be permitted to have trademark protection for your brand or logo on it if it's got cannabis, if it's got marijuana in it. Gets tricky with hemp and with CBD and with other cannabinoids. When it comes to topicals, even though there's other thing as a cosmeceutical, which is what a lot of regular nutraceutical companies sort of believe that there is when it comes to topical products.
That contain CBD.
Well, no, there's no such thing as a cosmeceutical at all.
No, yeah, sure, but for our context, we're talking about CBD products.
Right. And if you put CBD into a topical, into a cosmetic, you basically create a topical drug, which in theory would create a much bigger enforcement risk because, as you know, drugs require billions of dollars in trials and regulation. But at the moment, getting back to sorry, it's a long-winded way to answer this. At the moment, FDA and FTC don't seem to be prioritizing the enforcement of that particular part of the FD&C Act, and are focusing their efforts on ingestible products, so food and dietary supplements. We can ignore drugs for the moment. The only drug that would be relevant is Epidiolex or Marinol in this country. But they're not really, if you're not making outrageous claims about it and you've got a product that's a topical CBD product, it doesn't seem to be an enforcement priority. And the USPTO, as long as you certify that the products that you're applying for your protection for, the class that you're applying for, has come from hemp, what is certified as hemp, you will actually almost certainly get your trademark. I wouldn't say absolutely, but it does appear to be that you are able to get your trademark on those products. So what does that mean?
Dave, I think we've lost you there. You back? Oh, yep, you're back now. Sorry to interrupt. Oh, gone again. And
Hi, Dave.
Uh-oh.
he's frozen for a moment.
Well, the hazards of work at home for the foreseeable future.
That's right. Yeah,
I'm
I think
sure
he's back now.
we'll connect again in a moment. He's a little fuzzy right now.
I can hear you guys just fine.
Well,
Yeah,
carry on.
yeah.
We can hear you. You're a little hazy.
Okay. Well, I can see you guys perfectly. So anyway, so yeah, what does all that mean about your marks? Well, the first cannabis company to get a quote unquote trademark was something called Chiba Chews, and they got a trademark for I believe it was athletic wear and smoking accessories. And they went ahead and slapped that mark on all of their cannabis products. Basically, the reasoning being that they would not be enforcing their own, not only would they not be able to enforce their own mark against themselves because it's a different product, but they wouldn't if they could. And to the consumer, it gave them the ability to put Chiba Chews trademark. And so the idea with CBD at the moment seems to be, well, if you can get a trademark for a topical, you've got a trademark for a cream, say, and you can exclude people from using your trademark on CBD cream. But there's nothing that stops you from taking that trademark and putting it on a vape or a dietary supplement or a food. You won't be able to, that doesn't void your mark. The USPTO is not going to get mad at you for doing that. You just won't be able to exclude somebody else from using that mark on that class of goods.
The class of goods that might otherwise not be eligible for its own trademark because it's not lawful.
Correct. And I think that we're going to see an sort of an encroachment of marks for things that are tangential and ancillary to the heart of the matter. And people will just start slapping them on, and they've already been doing this. They'll slap them on all of their products as an attempt to kind of corner the market and establish themselves as that brand. Now, this also sort of leads us to another dichotomy in the trademark world, and that's the difference between federal trademark protection and common law trademark protection. To achieve common law trademark protection, you just use your product in the stream of commerce with your logo, your name on it, and you should be, as long as it's not a fanciful, as long as it's not a generic term, you should be granted, you should have a trademark. The problem is you need to go to court through a massively expensive litigation process to enforce that mark, which is why the Lanham Act created an administrative process in which you can go to an agency and say, hey, so-and-so is infringing on my mark. And it's a relatively straightforward matter. If you prevail, you can win up to, if it's unintentional, not willful, it's a $200,000 per instance of infringement. If it's proven to be willful, it's $2 million per instance. So there's seriously strong protection there. But it doesn't mean that there isn't protection just in general under the common law. And people tend to forget that. And I think that's important. And that sort of builds on establishing the brand through these sort of non-obvious channels.
Right. Yeah, and I do want to thank you for that, both of you. And I do want to kind of go back to just asking, you know, I've read a lot about trademarks having to be used for lawful activities under federal law. And I know you both have kind of touched on this, but can you just succinctly tell us, you know, what's the extent of trademark protection that's available for cannabis companies?
Succinctly, you know, you're talking to lawyers. So look, there are certain things that are fair game. USPTO or the FDA has generally regarded as safe things like hemp seeds and hemp seed protein. You know, we don't have any issues. You could get trademarks on things like that. There's no risk that there's a THC content in a hemp seed. And so because it's grass, hemp seed is considered grass, it's fair game. It's open season. So that you can go to Whole Foods, you can go to natural grocers and find hemp seeds all over the shelves. And those companies almost undoubtedly have trademarks for their brand. There are other things in cannabis that come into play that might be regarded as fair game as well. You know, things like educational materials. You know, if you're a news source and you're putting, you know, news bulletins online, or, you know, even hosting a podcast for, you know, where you interview experts in cannabis, you're going to be able to get protections for the services for that type of product. What we're talking about as, you know, ineligible are things that that the federal government does not deem to be lawful products. Dave, do you want to expand on that a bit? You still with us?
Yeah, I'm sorry. I think we've covered that. Anything involved with marijuana, you will not get a trademark for at the federal level. And currently, anything that is derived from hemp, well, CBD that's derived from hemp, if it's a dietary supplement or a food, and that's because of FDA rules. The interesting question there, and I have not seen this happen yet, I'm waiting for a client to allow us to raise this issue, is other cannabinoids that are not THC and not CBD, because then you have the whole analysis that it's not an active pharmaceutical ingredient in a approved drug, which is why CBD isn't permitted, because it's the API and Epidiolex. So I'm talking about, and not THC, so it's not a controlled substance. I'm talking about derived from hemp, CBN, CBC, CBG, except and all the cannabinoid variants, so CBDV. I think that'll be a very novel issue because if the FDA hasn't addressed it yet, then I don't see how the USPTO would be able to invoke the morality clause on that.
I agree with that. You know, there was a guidance issue. There's an examination guide that the USPTO issued last May. To my knowledge, it hasn't been updated, but it says that registrations of marks for foods, beverages, dietary supplements, and pet treats containing CBD will be refused as unlawful under the Food, Drug, and Cosmetic Act, even if the CBD in those products is derived from hemp. But it doesn't mention these other compounds, like Dave mentioned, that don't have a drug on the market approved by FDA with an active ingredient that is one of these other compounds like CBG or CBN. So I believe it's going to be open season for those products, and people are currently in the process of attempting to get trademark protections for brands that trade in these classes of goods. The last thing I would note, Rebecca, as to what is a legal sort of cannabis opportunity to obtain a trademark at the federal level. Dave said it earlier as a way of example, but lifestyle brands, clothing brands, you know, these sort of completely ancillary, doesn't actually have a, you know, product that contains a cannabinoid, those are going to be fair game as well. So we've actually helped dozens of businesses obtain lifestyle brands, clothing brands, athletic apparel, things of that nature for their brands, and some of them contain marijuana leaves. So it's not as taboo as it used to be. 6 years ago, if you had a pot leaf in an application for a federal trademark, you might be rejected flat out. But we have really seen progress in this area. And have been able to help a number of clients get protections for clothing brands and things of that nature, smoking apparel, smoking apparatuses.
Awesome. Great. Yeah. And do you think that's helpful? I know you've touched on it a little bit, maybe Dave, but do you think that's helpful securing those trademarks for lawful products right now that could then be transferred into products that are currently unlawful, like marijuana and things of that nature?
So it's a tough question, Dave. She asked you, you always take it, but.
Well, I was going to say that I actually literally answered this question for a client today in saying that, yeah, from a practical, from a brand building standpoint, sure, that's great. And obviously having a line in the sand of when you started using something is really important from a common law standpoint as well. But if you were to get a trademark protection for a regular moisturizer, and the idea being, when say CBD is permissible as or moisturizer is a bad example because that's already permissible. Let's use a dietary supplement. So you have a dietary supplement that doesn't have CBD in it, and you get a trademark on it with your brand, and it's perfectly fine. And your thought is, okay, when I'm going to put this on my CBD equivalent, and then it'll be easier for me to get a trademark at the federal level when the laws change. And that's just not the case. You're still going to have to go through the exact same approval process. It's still going to take you the same amount of time to get it approved. But in getting a mark, putting a line in the sand, where that does protect you is if someone says that they use that mark first, and then they try to make you change your name, or they try to trademark troll you basically. So yeah, I think there's and another way of doing that in a much easier level is to go to your state, whatever state you're operating in, and apply for a state mark. State marks in Colorado cost $30 and take 35-40 minutes to apply for at most. And that only gives you protection within Colorado, and it's not an administrative process at the USPTO, so it would still involve litigation. But what it does do is it gives you a clean timestamp line in the sand where you can say, I started using my brand on this product here. And that will help you defend against claims of other people saying they use it first. I think I addressed the question there.
Yeah, so I think another point on that is there are things, such things as intent to use trademarks, meaning I will use this in the future. You can't get that for a product that's currently unlawful. You can't say I am applying for a trademark with an intent to use it in a year and a half when the federal government passes some sweeping legislation and makes all marijuana products lawful. You're applying under the rules that are applicable on the date of your application. So as of today, as a snapshot in time, if you apply for an intent to use a mark for a marijuana product, you're never going to get it, even with the statement that you don't intend to use the mark until it's lawful. So what Dave's saying is you can apply for, call it a lifestyle brand, or do what Chiba Chew did and get smoking apparatus or some ancillary class of goods that's not a product itself. Once you have that mark, you can use that mark on unlawful products. It does not make your unlawful products lawful. It just means that the only group who could ask you to cease and desist from using your mark on an unlawful product is you. You've already got that mark. So it doesn't protect you from illegal activity. It just gives you the right to use your brand on that illegal activity.
Okay. Sounds
not
like
not legal advice to go ahead and do illegal activity.
Great. So we are talking a lot about the federal and state landscape, but I want to think a little bit bigger. Do you guys know of any international intellectual property protections for cannabis-related businesses?
That's a very good question, and obviously it's on everybody's mind considering there are now countries in which marijuana is legal at a federal or countrywide level. So the answer to that is a little bit, well, I'll default back on the patent thing and trade secret thing. Yep, those exist. And I don't really, and I can't speak to the enforcement of international patents, but I can say that in what we would call the regular world, the non-cannabis sativa L world, that's already really difficult to deal with. Just look at all of the fraudulent manufacturing of things that go on in China. Blatant patent infringement. But I think what probably is more on people's mind is trademark. And so USPTO concerns itself with all of the United States applications. There's something called the Madrid Protocol that something like 90% of the world's countries have signed on to. The United States is one of them, and so is Canada for the purposes of this discussion. And so the thought is, okay, well, can I get a trademark through the Madrid Protocol? The Madrid Protocol uses the classifications that are established by the Nice Convention. And so there doesn't exist a cannabis classification according to the Nice Convention. And so even if you would apply, once you apply in your home country, you apply to the WIPO, which is the Worldwide Intellectual Property Organization. And once you apply for your own, you get a registration at the WIPO, and then you can then sort of hub and spoke it out into individual countries, and it's far simpler, far easier to do that than to try to get one in every country. That's the attractiveness of it. But you can't, because of the way the WIPO is set up with the classifications, you can't actually, it has not been done yet, and doesn't look like it's even possible to get past that threshold to get registered with that international agency. However, so if you, let's say you could, let's just say they changed the Nice classifications and you could get that registration. Fine, that's great. You still have to go back out in that hub and spoke model to each individual country. And when you get down to that individual country's criminal laws will control. So let's say Canopy, for example, was able to get their trademark up through WIPO's kind of filter. It makes no difference at the USPTO level, because the USPTO's law is still going to control. The individual laws in the European Union, they're going to still control. So from a trademark standpoint, other than common law trademark, and if you think common law trademark is difficult to enforce in the United States, adding an international component of that litigation is beyond insane. There is no real international trademark protection for cannabis companies.
Yeah, I would only add, there are international treaties. Nations cooperate with one another to certain extents, but the answer to what international protections are available really depends on what country you're looking to protect in. The EU has has some consistent laws that might apply to any country within the EU, but the United States and Canada might have a difficult time enforcing, would have a very difficult time enforcing any kind of right conferred upon a United States company in the United States on a company infringing on that patent or trademark in the EU. So it's very complex and it's very expensive and very time consuming to figure these issues out. But the short answer is it really depends where you're looking for the protection.
The lawyer answer, it depends. All right, I like it. So we'll zoom back into the US and just curious about the current prosecution litigation landscape? You know, any notable cases or actions out there that you guys know of, want to talk about?
I'd mentioned the examiner's guide from last May that was issued by the USPTO that suggests that they're gearing up towards, more widespread CBD related applications. But we're going to need some federal legislation or FDA legislation specifically before a CBD, before generally there's like a CBD class of goods. Dave, you were mentioning a case to me the other day. I can't remember the name of it. Nah, I forget the name of it. There was something recent in prosecution of some company that had the name cannabis in it received a trademark.
Oh yeah, that happened 2000, right after the Farm Bill passed, and it was a hemp company got the word cannabis cannabis as part of their
Mark.
Their mark, which would have been a no-no in the past, and then I think that was the right decision on the USPTO's part. But other than that, I mean, we're kind of at a standstill until federal laws in general change.
Makes sense. So now is the time where I ask you both, what do you think the future is going to look like regarding the relationship between intellectual property and cannabis? I know you've touched on it. All my questions touch on things you've touched on before, but what do you think?
We have a hard time staying on track. I think in 2 to 3 years, there will be, hopefully less, there will be widespread changes to federal, if not enforcement priorities, federal law concerning cannabis, both marijuana and hemp. I don't know if that looks like a descheduling of marijuana from 1 to some lower number, or an outright descheduling entirely. I don't know if it looks like a states' rights act. That's what I think. There will be a states' rights act that says this marijuana itself is lawful at the federal level to the extent it's lawful at the local level, and that might open the doors entirely. The floodgates will be wide open, to use an analogy I apparently use a lot. So I think in the next 2 to 3 years, we're going to see a massive shift in the regulatory landscape. And when that happens, we're going to see a massive influx of brands attempting to get protection for their brands. I think most smart companies are implementing some kind of protection now, right? They've got common law rights because they've organized companies, they've got trade secrets, they maybe have applied, for more than common law rights with a lifestyle brand, and they're going to seek to probably consolidate, and there will be a few key companies that hold a lot of IP that's used in this industry or these industries. But right now, like Dave said, we're at a bit of a standstill until we have some landmark litigation or some landmark legislation. But I have no doubt that in a few years, everything will be different, and what we're talking about now will seem like an ancient relic.
I think that was well said and done. I think that the biggest implication of future interaction with intellectual property law is also the single most ignored and most overlooked landmine in the industry. And what that is will be a spate of patent trolling.
Yeah.
Like I said, there are something like 3,000 patents that have been issued. Some issued as far back as the 60s, so they're basically either already expired or about to expire. Some that are very, very recent. And then patents, like I said earlier, have something like 20 to 30 year lifespan. So if plant patents are difficult to get, but let's say you were to get a plant patent on a strain, and all of a sudden you can enforce your patent in federal court, you are going to patent troll the entire country, and you'll become the cannabis version of Monsanto. not only has this happened in the past with plans, and we have a textbook example, but it'll happen with other things that aren't currently patentable, currently enforceable, that are patented. So when I started this whole conversation off saying that patent protection is something that we don't encourage our clients to do because they disclose their secret sauce and they can't enforce it. The caveat to that is that they're playing the ultra long game, the ultra risky long game. There could be some advantage to getting a patent now and banking on legalization before that patent expires, and then licensing that patent and enforcing your rights across the country, because no one will be, you'll be able to levy huge fees. And I don't want to sound like I'm in favor of this. Patent trolling has its own set of morality involved in it, and we don't need to go down that rabbit hole, but I'm just calling it like I see it. I believe this will be the largest wave of patent trolling we have ever seen, because there has never been an artificially pent up demand like this.
Let's expand on that a little bit, because I was actually thinking about exactly this issue earlier. So patent trolls own the rights to patents that they can't enforce yet. One day they will be able to enforce. And let's say someone's got a patent on a strain like Gorilla Glue, which is a very common strain out there. I want to be clear, I don't think, Dave, you are a doomsday prepper here. You're hailing the end of the industry because of patent trolls. It is a very serious issue and something to be concerned about. But what I was thinking of earlier was, when we talk about something like Gorilla Glue, if you and I own a cultivation facility and we're each growing Gorilla Glue, you might get some genetic testing, and those strains are wildly different.
Sure.
So the genetic composition of what is colloquially known as Gorilla Glue might differ from business to business, from gram to gram. So there are some, you're going to have defenses. That was really what I was thinking about from a litigation standpoint, because patent litigation is expensive, as is defending patent litigation. Just trying to think causation,
Right, so think about that for a second. So if I've got the patent for Gorilla Glue and I've established what its genetic profile is, and then you market something that's called Gorilla Glue, and I can show that I did it first, your defense to my patent troll claim is basically fraud.
Is what?
It's fraud. If you've been trading on my name, you have a Lanham Act and a general fraud issue by calling it Gorilla Glue. So by saying, oh no, it's not genetically identical, I'm not ripping you off, Dave, you are admitting to another whole set of legal issues.
But there's also the idea that Gorilla Glue is such a pervasive name out there.
Right. I don't think we can say like that analysis does not necessarily going to apply to existing names. We'd have to extrapolate this out to some killer new strain that is
created in 2022.
Yeah.
Okay. No, it's really interesting. Again, maybe not to everybody, but the fallout of these patents and these patent trolls and what they're going to be able to do to disrupt the industry, even if there's no merit to claims, the disruption to the industry is going to be staggering. So, a lot of our clients need to be prepared for that.
Well, yeah, I mean, think about what that will coincide with. That will coincide with the potential for centralization of production in places where it's cheap and distribution to places where it's not. So right. You'll have big conglomerates, just not to fall back on them again, but Canopy, for example, who's already laying the groundwork for this at a very large level. At the same time that you're able to flood the market with massive amounts of product at low price points, you're also able to prohibit people from copying your product for the first time. I think that 1-2 punch, I'm not in any way predicting the end of the marijuana industry. I'm saying it is going to reshape the marijuana industry in ways that we have not even come close to conceiving as a group.
Right. To that point, it's best to start now, preparing for that, prepping for that, being ready with your own protections to the extent possible.
Awesome. Great advice, you guys. That was really interesting. I think we do have some time, so we'll turn over to the attendees, see if they have any questions for us here. We have one that we've touched on quite a bit. What is the difference between patents and trade secrets? I don't know if you guys have any final thoughts on that, or you feel like you've covered it?
I feel like that we've covered that particular question.
Awesome. Yeah, it looks like they asked it when you were talking about it. So if I would have been looking, we would have known. So moving on, any tips for building a strong brand outside of intellectual property?
Be ethical? I'm not sure what that question means. I think, you know, do good business is obviously that, but maybe if they're asking from a more legal standpoint, your IP is only as strong as your ability to enforce it. So keeping a strong balance sheet and being willing to engage in infringement litigation is a must. And also, I think we touched on earlier, the ability to have bomb-proof contracts where you clearly allocate the rights and the limitations on those rights as you put your products out into the market. I think that's something that we see overlooked all the time, and it's something that is a no-brainer. If you've already put all the work in to get that IP, whether that's, you know, going through the process of getting a trademark or filing a patent or just creating your company, to let that all fall by the wayside by having poorly written contracts is just a tragedy.
Yeah, to piggyback on that, I think I understand the question. You know, what can you do outside of actually applying or protecting IP rights, meaning other than applying for a trademark or a patent? You know, what is it you can do? Separate your assets. You know, as a business, it may not be in your best interest to both manufacture a product and own the intellectual property related to that product in the same company. So if company X manufactures a CBD product, you might want to create company Y to hold the intellectual property. And as Dave said, contracts are important there. You can separate those assets out. Now, one company manufactures, one company licenses IP, and if company X is sued based on some, you know, some issue with the product, some health risk, some, you know, contract breach, company X is sued, but the plaintiff in that case cannot in any way attach the assets owned by company Y, the intellectual property itself. So like Dave said, balance sheets are very important. Keeping your assets separate and protected from a liability standpoint, I just can't overstate how paramount that is for any business.
Well, and, you know, if you break out your IP company and your manufacturing company, in addition to the protections from liability, you open yourself up to a whole wide world of interesting finance opportunities. And what I mean by that is, well, like basically what happens with tax. If you set up company Y in, say, the BVIs, where there's a zero effective tax rate, and you are licensing that transaction back, that IP back to the United States, where does that transaction happen? The established case law is that transaction happens in the BVIs. So that is a tax-free transaction. And so you see massive companies do this all the time, where all their IP is held in either a state with lower taxes or in a country with lower taxes. And then their overall bottom line is massively enhanced because they're paying themselves a licensing fee, basically, and being able to scoop that money out of the company below the top line so that their overall tax rate is, you know, a quarter as much.
Yeah, and both of your answers, you brought up licensing throughout, and I'm just curious, we'll get back to attendee questions in a moment, but I'm curious about royalties and if there are any caps on that for this sort of thing that you both know of.
Depends where you are and what industry you're involved in. From a marijuana perspective, there are, you know, you don't have federal legality for marijuana products, but you do have essentially to date the federal government saying, look, you follow a state regime and we're not going to bust your doors down. So really you've got to look to each state. In Colorado, for example, where Dave and I are most familiar, the Marijuana Enforcement Division is the regulatory agency that oversees marijuana businesses and their contracts and relationships with other parties. So if you own intellectual property for some marijuana infused brownie, let's call it, and you license that intellectual property out to a manufacturing facility here in Colorado, and your compensation is royalty based, there are caps. The state has a 30% cap, basically no questions asked. But if you go beyond that, you might have to get approval for the contract. Various other states have various other caps. Really, the buzzword is commercially reasonable. So, if you are an IP company and you license out this space brownie to a company in Colorado or a company in California or a company in Washington, and you're seeking to get 90% of the revenue, generated from the sale of those products, is that commercially reasonable, that royalty? Probably not, but it's going to be a fact-intensive case-by-case analysis.
Okay.
As to CBD products, non-marijuana goods or services, I'm not aware of any caps.
Great. Interesting.
Commercially reasonable.
Yeah, great keywords there. It looks like we do have one more question. How do I know if my company has something that can be patented or trademarked?
When you know. I mean, it's not as cut and dry, or it's not as difficult as most people think, but the key is to do your research. If you create a product and you call it Nike, right? It might be a novel product, it might be something really unique, but your issue is it confusing? Is there a source confusion? Are people going to think that Nike is manufacturing this product? Nike,
not, because Nike is going to send some very high-powered lawyers to your door and force you to stop doing what you're doing and pay you a lot of money for having done it.
Right. You're never going to see a roofing product that's labeled as Nike. Nike operates in this, sports goods and outdoor products space, and that's their bread and butter. And maybe a lawnmower could be called Nike one day, but I guarantee it won't be manufactured by John Deere, right? So do you have something novel and interesting that you could maybe apply for patent on? Okay, great. Do you have a brand that you've created for this class of goods that you're trading in that's that doesn't already have somebody who's marked or received protections or entered that type of product in the stream of goods with a similar or confusingly similar name? So you've got to do your research. There are handy searches you can do through the USPTO's website. A deep dive is difficult and complicated, but if you have something cool, it might be marketable. You just need to make sure you're coming up with a name that isn't going to confuse an average consumer.
I can break it down even more fundamentally when it comes to patents. I mean, if you have something that's of a patentable subject matter, that is novel, that is non-obvious and is useful, you can apply for a patent. That's it. I mean, now the definition of what is a patentable subject matter and what is non-obvious, that actually can get quite technical, but on a broad level, that should be kind of a gut reaction. You'll hire a patent attorney if you really want to go that route, and they'll tell you if there's anything that exists in the prior art. That's part of what they do, and it's very expensive. But yeah, I mean, those are the four broad strokes that you can use to determine whether or not you have a patentable product.
Great. And hire these guys, not just any patent attorney, right?
No, we actually can't do.
We're not patent attorneys, so don't hire us if you want a patent review. But if you have questions about trademarks or trademark enforcement, yeah.
Or if you want to litigate over patents, you can talk to us. But no, we cannot secure you a patent.
All right, I was wrong there. But let's see, any more questions from the attendees? Don't see any rolling in, so if you guys have any questions, feel free to email or give us a call, but we'll wrap it up here. Thanks so much, Dave and Nadav. Really appreciate you guys taking time to discuss this topic with me. Thanks to all of our attendees who logged in today, and thanks for your questions. And If you have any ideas about webinars or topics that you want to see, issues that you're curious about, just give us a call, shoot us an email. We want to know. We want to make these things exciting and fun for you guys to watch as well. And we'll put up the disclaimer once again. And I believe just log off. Thanks so much, Dave and Nadav. Appreciate it.
Thanks, Rebecca.
Rebecca, thank you for putting this all together.
All right.